To help us better understand the ruling, its ramifications, its impact on society, and what it means for the state of Texas, joining me as a regular contributor on the show, the Honorable Vanessa Gilmore, retired judge of the United States District Court for the Southern District of Texas. Welcome, Judge.
Thank you, and good afternoon.
Good afternoon. It's good to have you back. So, Judge, help me understand this, that in making one decision, is it simply the knowledge that it will have a backward effect on earlier decisions that they spoke out on this? Why wasn't it just left as their decision on Dobbs v. Jackson?
You know, originally, when the Mississippi case was filed, they weren't even seeking an opportunity to have Roe overturned. They were just there on the Mississippi law. And I think that that's what the Chief Justice was trying to focus on in his concurring opinion. We weren't here originally when Mississippi came to us with this case to deal with overturning Roe. There was no split among the circuits. There was no reason for that issue to come before the court, except that they wanted to be able to address and look at whether or not they should overturn Roe versus Wade. And so the reason for the split, as Rocky mentioned, Chief Justice Roberts wanted to uphold the Mississippi 15-week abortion ban, but he did not want to actually weigh in and get rid of Roe through this opinion.
Judge, I'm right up against a break, but I quickly want to ask your thoughts on that and the idea of how do we balance this in our own state?
Well, interestingly, I'll have to take off my judicial hat, or my former judicial hat, and put on my hat of community service, because I work on a number of the issues that your last speaker mentioned. Medicaid has not been expanded in the state of Texas. The state continually pushes back against expanding Medicaid in a way that would protect and help children. And as far as being able to provide services for children up to 3 years, there's no free education in Texas available until you're 5 years old. And so I work extensively within the foster care system as a volunteer, and there are over 17,000 children that are in foster care in the state of Texas, many in emergency temporary situations because we don't have enough foster families to take care of the children that are born. And so I would have to say that with respect to the provision of services, there is not a lot enough there to protect the children that are born to families that do not have the resources available to them to give these children a good life.
Judge, then on the concept of a right given and then taken away, I've heard it said a number of times today, this is the first time that has ever happened. Is that accurate?
This is the first time that it has ever happened, that a right that the Supreme Court has previously recognized has been then taken away. And when you get to the point of discussing what rights have been provided to the United States, to the people of the United States through Supreme Court precedent, there are a number of other rights that are based on the right to privacy that are now part of what we consider to be settled law in the United States. The right to have contraception, that was decided by the Supreme Court in Griswold. The right to have privacy in your own sexual relationships, that was decided by the Supreme Court. The right to same-sex marriage, and even the right to interracial marriage. Except that today, Justice Clarence Thomas in his concurrence said that the justices should also reconsider other cases that rest on the right to privacy, specifically cases protecting contraception access and same-sex relationships. His quote was, "In future cases, we should reconsider all of this court's substantive due process precedents, including Griswold, which was the contraceptive case, Lawrence, which was the privacy and sex case, and Birchfeld, which was the same-sex marriage case." Disingenuously, however, he failed to mention Loving versus Virginia, which was also decided on privacy grounds, and that is the right to interracial marriage. And so he sort of conveniently left that out, probably for obvious reasons. But if he was going to be completely genuine about his criticism of the court and the need for it to go a step further in looking at these other privacy rights that were granted by the Supreme Court, he should have also mentioned Loving versus Virginia.